Hey everyone, Natalie Teston, family law lawyer in Northeast Georgia. I'm here today to talk to you about discovery. What is discovery? Discovery is court-sanctioned investigation. It's a process we get to engage in all our civil cases, such as family law cases, that help us assess the strengths and weaknesses of our case and see what's likely to come out at trial before we actually get there. It's essentially our way to see what a dress rehearsal of trial may look like before we get to the big show. In discovery, we are allowed to ask questions of the opposing party and get their answers to those questions under oath. We're also allowed to access records such as bank statements, voicemails, text messages, retirement statements, all sorts of things like that. Recordings, audio recordings, whatever they may be out there in the form of documents or recordings, we're allowed to access that through the process of discovery. Georgia case law favors broad and thorough discovery, and the reason for that is probably clear. The idea is that if both sides fully and thoroughly respond to discovery, really show the other side what's likely to come out against their client and their positions in court, that cases may settle more reasonably and more frequently, right? If you don't have a chance to see what's coming against your client and your positions ahead of time, you may be feeling pretty confident, right? Nothing can take us down. We're going to prove this beyond a reasonable doubt. Let's go. We're going straight to the courthouse. They can't touch us. But if you do discovery ahead of time and you see, whoa, here's our position, but they've got these three pieces of evidence that actually call that into question, you realize that there's two sides to the story and that we may not be able to prove so clearly things that we thought we were. Or it's going to come down to a credibility contest. Or you may know your judge very well and realize, I know our side of the story is right, but when that judge sees this over here, that judge is not going to care about our side of the story over here. And so it helps the lawyers to give advice to their clients on what's likely to happen at court with this mountain of information. And when you kind of have a more laser focus of what that result might be, it helps settlement prospects, right? I mean, it narrows down things that you ought to settle for because you know a little bit closer of what's likely to happen at court. So there's no sense in spending the time, the money, the emotional turmoil going that route if you can kind of already see in the crystal ball what things are likely to result in anyway. Discovery, we can engage in four different types, or we have four different tools that we use in our discovery process. First would be requests for admissions. The point of a request for admission is to just take things out of contention, right? We ask very focused questions and the answer is either admit or deny to those. And so think of a case where we are trying to secure primary custody. You may want to send requests for admissions on things like admit you have never been to one of your child's doctor's appointments, admit you've never spoken to one of your child's teachers, admit you've never purchased back to school clothes for your child, admit you don't understand what medications your child is on and why, stuff that's very small. And so the idea is if you can get real quick admissions to that, okay, you admit that you've never been to one of your children's medical appointments, well then I don't need to go and spend the effort to put the doctors under subpoena to come in to testify that no, they don't know who this person is and they've never seen the other parent, or go subpoena the records and look through them and make sure that this other parent really wasn't at any medical appointments. I can just rest on the admission. They admit they've never been to a medical appointment. Moving right along. It just narrows the scope of trial and contested issues and keeps things moving forward. There is no cap on the number of requests for admissions that we can send, which is also a nice thing. So sometimes you send requests for admissions, you get more evidence, you send another batch over. Of course, it can't be unduly burdensome or oppressive or anything, so probably 1,000 would be out of the question. But technically in the code, there is no cap on them, so that's nice. The other tool, number two, second tool that we have in our tool belt in discovery is interrogatories. Interrogatories, we are capped. We can only ask 50 questions, and that includes subparts. An interrogatory asks a question, and the other party is supposed to answer that question fully and under oath. So in questions or in cases where we have questions such as we know child custody is up for discussion, everybody wants to be primary, but why? Then ask the interrogatory. List everything that my client has done wrong as a parent. And you get a bigger answer than just admit it or not, right? You're going to get an answer that says, well, for first, this person did this person did that, this person did this. And so then we finally have a good list of, okay, this is the type of stuff that's going to come out against you at court. So let's either go find the counter evidence to that, or let's brush up because you got 12 things here that you need to work on. And if you complete that task, it's a good cross-examination to that person at court. Well, you said this was the only things that they were messing up on as a parent. Looky here, we fixed all those for you. Any other questions? Seems like we're ready for a shared custody arrangement, right? That's a good, just again, a little peek behind the scenes of what's coming out against you at court. And then if you see it before court, you've got time to pivot, readjust, get the stuff that you need to blow that argument out of the water, right? The third tool that we have is called request for production of documents. These again are unlimited in the code section. This would be where we say, give us all your bank statements from every account that you're on, individually, jointly with another, on with as a business, etc. I want to see all your credit card accounts. I want to see all your text messages with your children. I want to see all your text messages with your other parent. I want to hear all video, audio recordings that you may have of my client. 911, police report, stuff that you're putting together for court. I want to see it before it comes out at trial. And that way we can look through and realize the strengths and weaknesses of our cases again, and things that we may need to shore up on our end. Finally, the fourth tool that we've got in discovery is called a deposition. That's where we literally send a subpoena to either the other party or some non-party, maybe a boyfriend, a girlfriend, maybe a teacher, maybe a therapist, whoever it could be, to call them into one of the lawyer's offices and give testimony under oath. I'm asking questions, that person's answering under oath, and we've got a court reporter there taking it all down. So that's a good way to just sort of live in the moment with your questions. You know, an interrogatory, if you've got sort of a vague response, let's say, oh, they're a horrible parent for too many reasons to count. I guess that's technically a response to the interrogatory, right? But I don't have the ability to follow up. At a deposition, if I got that answer, I would say, okay, well, give me the top 3. Or you can start asking, do they go to medical appointments? Are they involved in school? Are they involved in extracurricular activity? Do they have a bond with the child? Do they, to start knocking out potential issues? It gives you the ability to just sort of ask questions on demand and have more of a free-flowing conversation with somebody versus just answer these rigid questions and we get them back and then we, don't have a good chance to follow up timely. We'll put it that way. So that's our 4 tools that we have in our tool belt for discovery. In certain cases, we use none of these, right? Folks that already have an agreement, they just want some lawyer to draft up some documents, keep things super calm. As long as our client has been made aware of what discovery is and that our advice is always to do it, and they want to move forward without it, fine with us. And then in some cases we use just 1 or 2 of those tools. Some cases we use all 4. It just depends on the case and the allegations that are there and the evidence, the particular evidence that you're looking for. And so discovery looks different in every case. Sometimes it's limited, sometimes it's extremely broad. We must get cracking though on discovery. The code says that discovery starts when the answer is due, if no answer is filed, or if the answer is filed that day, and it goes for 6 months. So we can't really wait around too long. For good cause, the court can expand or contract the discovery time period. Again, since cases, our case law out there says that we favor broad and thorough discovery, and judges like it because it helps settle cases. You're more likely to get it expanded to say, Judge, I've been promptly and diligently following up on discovery. I still have 2 or 3 things that I've got to have in order to have a proper trial in this case. If the judge sees that you've been diligent along the way during those 6 months, you're pretty likely to get that extended out a couple of months to let you finish up. But in a case where, let's say it's drug on for 2 years and no one ever sent the first request for 18 months, now you say, oh my gosh, we got on a trial calendar, I need to do discovery. You may not be able to convince the judge that you should expand that time frame if you've not done anything thus far. So for good cause, you can expand or limit it. The judge is always the gatekeeper on discovery. They hate getting involved in discovery disputes. Our uniform superior court rules say that the lawyers are supposed to work together in good faith, use their professionalism to try to hedge through discovery issues. It's not uncommon that we see a request that we think is just overbroad. If it's a 2-year marriage and someone sends me a request for 10 years of bank statements, I'm going to object to that. Who cares what was going on in the 2010 if this is a 3-year marriage? here, I'll provide you with 3 years of bank statements, but I'm going to object to the rest. And so the lawyers can kind of work together to have good faith conversations to see if we can reach a middle ground on any discovery disputes out there. Or, hey, you gave me this answer, I think that's a little vague, I need you to give me a little more detail. Well, what code section are you looking at to say that I've got to give you more detail? Well, here's the code and here's the case. You've got to answer it fully, you've got to answer it under oath. Okay, I see that. Let me circle up with my client, we'll get back to you. That's how it's supposed to work. It doesn't always work that way. If a lawyer or a party feels that the other side is not playing fair, or even a non-party, with discovery, they can file motions to compel, motions for sanctions with the court, or the court can get involved and either order and compel the production or the giving, the access of whatever you're out there after, and can also smack the other side or the person that's causing the motions to be filed with attorney's fees and other sanctions. The highest sanction that a court can hit against somebody is a dismissal of their case. And it's rare in family law, but it's still possible. But also being able to strike out positions. Okay, you don't want to show us what your income is? Let me make this very clear. You don't get to have a position on alimony. I'm striking it from your pleading. You're not asking for it, or you're not denying that it should be awarded. How about that? So there are some serious sanctions associated with failing to properly engage in discovery. So discovery is an important right at your disposal as a civil litigation litigant. We use it very frequently in family law cases. That's a lot of times where the emotions and the tensions drive up in family law cases, right? When we have to call in someone's paramour for a deposition to get some answers to some tough questions, that's a rough day, but it's an effective day. So if you've got any more questions on discovery, certainly this is just general overview. Your case is unique and special. Go to your specific lawyer for really detailed advice, but here's just a little overview to give you a little something to chew on. Don't forget to like and subscribe. We'll see you on our next video. Thanks, guys.